Welcome, everyone, to today's Fireside Chat with SEC Commissioner Hester Peirce. My name is Josh White. I'm an assistant professor of finance at Vanderbilt University. Before introducing the commissioner, I definitely want to thank the CBER organizers for making this webinar possible. And a special thank you to the commissioner for taking time out of what must be an especially busy period in Washington, D.C. to join us for this conversation. So thank you.
Well, thank you, Josh. It's great to be here, and thanks to the organizers as well. I'm glad to be able to have a chance to talk to people who I don't always necessarily get an opportunity. You know, I talk to lots of lawyers, but finance folks don't come in as often. So this will be great for me as well. I hope we can keep it conversational. And I have to give you my disclaimer, which is something that we always have to give, which is that my views represent my own views as a commissioner, not necessarily those of the SEC or my fellow commissioners.
Thank you. And similarly, I have to give a disclaimer as well. I'm currently affiliated as a senior advisor at the Public Company Accounting Oversight Board, or the PCAOB. They too disclaim responsibility for any statements of employees, so the views are my own and not those of the board members, or the staff. So with disclaimers out of the way, we can move towards conversation mode. Let me give you a brief introduction and just sort of read your bio for everyone. So Commissioner Hester Peirce was appointed to the SEC by President Trump and sworn in January 2018. Before joining the SEC, she conducted research on financial market regulation at George Mason's Mercatus Center. Her previous experience included serving as senior counsel on the Senate Banking Committee and also as counsel to former SEC Commissioner Paul Atkins. Commissioner Peirce served as a staff attorney as well at the SEC in the Division of Investment Management, worked as an associate at what is now WilmerHale, and clerked in the U.S. Court of Federal Claims. So she's one of the rare people that has degrees in law and economics. She has a bachelor's degree in economics from Case Western Reserve and a law degree from Yale Law School. So for our format today, just so everyone knows in the audience, we're going to start with a discussion between the commissioner and me, followed by a Q&A session. As we go along, there is a Q&A function, so you can drop your questions into the webinar. I will moderate those, so that way, if there's some questions that sort of fit into the organic discussion we're having, I'll try to weave those in. Otherwise, I'll save some time at the end and we can answer those questions or whatever questions you may have. Okay, hey, with that, let's sort of pivot towards the discussion. And so I know the audience is going to be eager to learn more about things that are going on or things that may happen after the election. But before we sort of dive into any of that, really what I'd like to do is sort of start with what your views may be and reflections on some of the key challenges that the blockchain and crypto space has had. And so I think it's probably fair to say that a lot would characterize the past several years as a lot of regulatory uncertainty in the space. I know industry has a phrase is regulation by enforcement. There's been quite a bit of enforcement activity in that space. So I guess the question is, do you think that's a fair characterization? And if so, what kind of impact has that had on investors, on consumers, on innovators, and sort of in this space?
I absolutely think that regulation by enforcement is what's been happening at the SEC, really in the U.S. with respect to crypto. And I think that's extremely problematic. So when I describe the SEC to people, I don't describe it as a law enforcement agency. I describe it as a regulatory agency, which is what it is, that has a law enforcement function that helps to back up the regulatory function. And so typically what you do is you write a rule and then you help people as they think about how to apply it to their unique facts and circumstances. And then when people don't apply it, you go in with enforcement. You don't try to write regulatory frameworks using one-off enforcement actions or a series of enforcement actions. And you don't do that for a lot of reasons. One, if you do it that way, you really discourage good faith actors from getting into the space. You end up, we've seen in the crypto space, you have a company that's going along for 5 years, and then the SEC comes in and brings an enforcement action and essentially shuts it down. And that's not a good way to encourage people to come to the US and build things, right? If there's this fear that they're going to be shut down. So the second problem I think that you end up with is you end up with, if people decide, you know what, I don't want to litigate this, I want to settle it. So you end up with a settlement negotiation that happens behind closed doors for obvious reasons. And then coming out of that settlement negotiation, you get an order which goes through and explains what the violations are and then explains what the remedies are. And people look at those very closely because those orders can kind of become a roadmap for what other people end up feeling they have to do. And so you effectively are writing regulatory framework in these backroom negotiations where the power is all in the hands of the SEC. The settling party just wants to settle and be done with it, so they have very little leverage. And people who aren't in the room at all have absolutely no leverage. And so that's a really problematic arrangement, a problematic way to write rules. And the other piece of this that's really problematic is that it's just not an effective way to regulate. We don't have the resources to go after every single crypto project and every single crypto intermediary. If we wanted to do, we couldn't do it within our statute of limitations. We don't have enough resources to do that. We'd be litigating these cases for years and years and years. And so from an efficiency standpoint, what you want to do is you want to set up rules so that people know what they have to do, and then you can spend your resources going after the folks who aren't complying. Now, I think one of the other big challenges in the crypto space has been that there has been a lot of fraud, and it's been big dollar fraud. It's been fraud that's been splashed over all of the newspapers, front pages. And so we all know that when something is popular, as crypto has been over the past decade, people will use it to do terrible things to other people. They'll say something is a crypto thing, and then they'll take advantage of other people. And so you do want to make sure that you save enforcement resources to go after the bad actors. Now, whether that falls within our jurisdiction or not is another question, but some of it does fall within our jurisdiction. And that's where I think our enforcement can be most valuable. And when you spend all your time working on registration cases, which is, we're arguing people should have been registered with us, but they weren't, then you have fewer resources to go after the frauds.
That makes sense. And I'm sure it's a challenge for any regulator to sort of know what's the right amount of enforcement, and are we enforcing sort of rules of registration versus more significant fraud.
Well, it's challenging. First of all, registration violation isn't, it's not fraud. It sometimes we bring them side by side. You didn't register and you also defrauded people. So and there is room to bring cases where it's just a registration violation. I should be clear about that. If you have a framework in place that's clear, that's one thing. But it actually, in this instance, I don't think it's that hard for us to figure out that we've been doing this wrong. And so I don't cut my agency that much slack. And again, it's not the staff at the agency. We're a commission. We're run by 5 commissioners. We're the ones making the decisions about whether to sue. If the word had come from the commission, go write a regulatory framework, we've got a lot of capable people who could have done that. But we chose not to do it. And so it actually, I think, is pretty obvious at this point that this wasn't a good way to go. It's hard to backtrack when you go down that road, but I think we know that we're not on the right road.
That may be a good time to sort of think about what we could do now. And I guess as we have this conversation, I want to break it out into different time periods. Of course, we're in the transition period now. I would expect at some point there will be potentially a new acting chair of the SEC. And then after President Trump is sworn in, of course, there'll be a permanent chair sort of selected. In terms of after Tuesday's election, there was an immediate surge in crypto prices. There's a lot of enthusiasm. I've seen articles, including this morning, that there's a shift in DC, not just at the president's level, but also in the Senate. And so I think that it may be a more supportive environment, or at least thinking about different things we can do to establish safeguards or rails in this space. And so I want to step back and think about what the SEC could do now. I'm sure if the audience is not familiar, maybe you could explain the pace and length that it takes to write rules because of the notice and comment period. And so what could be done now in the interim to maybe reduce some of the regulatory uncertainty before more sort of long-term fixes are in place?
Yeah, Josh, I think that's a good way to think about it, just in terms of you've got to think about what can be done immediately and what's going to be longer term. And writing rules is a long-term project, not only because you have to put out a proposal, which typically you want to allow at least 60 days for people to comment on it. And then you have to read all those comments, incorporate them into your thinking, and come out with a final rule. So that process can take years. Um, and you also, with something like crypto, where there are a lot of questions about how to approach these things, you probably want to start out with either a concept release, which is this idea you kind of lay out, here's where we think the regulatory intervention might be needed. These are the problems we're trying to solve. What kind of solutions should we be exploring? Um, or you might want to do a roundtable, or you might want to do a roundtable, bring people in from the outside, have these conversations, get a sense of where people think the problems are and where rules are necessary. So that process can really take a long time. There certainly are things that we can do immediately. One of the things that has caused traditional banks and broker-dealers to avoid participating in this space is something called a staff accounting bulletin. And as its name suggests, it was issued by the staff. And so something like that can be withdrawn. And then I think we'd see more interest from banks and broker-dealers in participating in this space. There are definitely some guidance documents that we could put out to help people think where the securities laws don't even apply at all. And I think that is an important theme, maybe that we'll see in the coming years, which is trying to really figure out which regulator belongs in which space. And we've tended to sort of think of crypto in connection with the SEC, because the SEC has been so active from an enforcement standpoint. But there are many things that people can do with crypto and blockchain technology, as I'm sure all of you know, that have nothing to do with the financial system. They're not financial assets. And so even starting out by providing some clarity there, I think would enable people who want to do development type things in those spaces not to have to worry about the SEC, about being pulled into the SEC's regime. So I'd like to see us provide that kind of guidance. And then I think you could set up some kind of, I've suggested both a safe harbor for issuing tokens or coins, which I think you could set up pretty quickly as an exemptive. We have rules that allow us to give exemptions, or to write exemptions, or to give no action relief. We could do that. And I've also suggested creating a sandbox type environment where you could do experimentation. It would be within the regulatory perimeter, but it would be it would allow you to try some new things. So I think those are some early approaches that we could take. And, frankly, we've said come in and register for a long time to firms. And if we actually committed ourselves to working with firms, but I think in having dialogue with firms, I think that could really improve things. Frankly, that's not just an issue when it comes to crypto. I think in recent years have been much less willing to engage with people. And so just opening the door more broadly and say, no, we really do want you to come in if you have questions about how this works, or you want to think about ways to move forward that will be compliant with the rules, but may require some adjustments. Come talk to us about that, and we'll try to move forward in an expeditious manner.
Yeah, so it's a regulator that I guess works with entrepreneurs or businesses that are working in this space. Probably would have some impact on part of the SEC's mission that maybe has been less promoted, I guess, in the last few years, and that's the capital formation side. So I wanted to know if you could talk a little bit about sort of the SEC's trifold mission for the audience here. I think everyone, when they hear SEC, maybe investor protection, is one of the first things that comes to mind. But when you mentioned the staff accounting bulletin, and maybe it had some competition effects on traditional banks and broker dealers wanting to enter the space, like how does that impact capital formation, and what's the SEC's role there?
Yeah, so the SEC does have a three-part mission, as you mentioned. It's investor protection, facilitating capital formation, and fostering fair, orderly, and efficient markets. And so we do sometimes, I mean, I think all of those three prongs work together really well. Part of protecting investors is making sure that they have access to opportunities. So I would say, we can think about them all together. We have to be careful in the crypto space because I think some of what we've been doing has been more in the consumer protection mold, and that might be actually done better by other regulators. I do think there's some interesting work to be done, and maybe this is something that your audience can think about on the marriage between crypto and crowdfunding, for example. And so crowdfunding in recent years, I think, has some of the during COVID, we gave some relief around crowdfunding. And I think that breathed new life into it. And well, maybe that, and also the fact that people saw that their local businesses were struggling. And so having a model, which crowdfunding is intended to draw little bits of money from lots of people, having a model where a small business could actually do that, I think also sort of energized people. But is there a way we can marry that with crypto to make the crowdfunding more efficient? Again, that's something people can think about, and I think we're always looking for new ways for smaller, newer companies to raise capital, and so crypto could be a way to do that. A lot of the crypto tokens we've seen, though, really are not they're not giving people an equity interest, or they're not giving people a debt security. So again, query whether some of this stuff really just fits better in the consumer protection model, which is not even at the SEC.
So do you, given that other agencies will probably need to work together, do you envision sort of some interagency action, after sort of the dust settles and the president is sworn in, and then of course there's going to be change in leadership at many of these different agencies. But once that takes place, is this something that's really going to take an interagency effort, or is it going to be siloed, I guess would be?
Well, I think that that's a very good point too, and that is something that could be started early on, which is having conversations that involve multiple regulators. Certainly, the SEC and CFTC have had many opportunities in the past to work together, and there's a mechanism that we can use, that we can stand up to have more formal conversations about these issues. So I think we can do some of the legwork for Congress in talking about where our jurisdictions meet and how we might work together on things. Ultimately, Congress has to make the determination of whether they think one or both or neither of us is the right one to regulate pieces of this space, but I think we can help them by having some of these conversations. And it's not only the CFTC, it's other regulators too. There's a Financial Stability Oversight Council that brings together the heads of a lot of different regulators. That's an organization that can foster some of this cross-agency work. And then there's also work with other, international groups as well.
Gotcha. So with the international groups, maybe I can ask you a little more about your digital security sandbox idea. So we started out talking about how there was some uncertainty in the regulatory environment in the US. The crypto space is new, I think, for all regulators. And so I imagine that including regulators like the UK or other areas of Europe are also adapting as things evolve and new products are introduced or new challenges are met. Can you talk about a little bit, I guess, more about the idea of the sandbox? Sort of what does that provide entrepreneurs, and what are the sort of knowledge spillovers to regulators? How could they also sort of learn from that setting?
Yeah, so the UK has been forward thinking and trying to figure out how they can work with innovators in their jurisdiction to pilot certain projects. So they've got their digital security sandbox where that can happen. And that would be small scale projects that are capped in terms of how big they can get. And so the idea was that, that's inspired me to think about, well, what could we do to maybe work with international regulators? Because a lot of these international regulators have been more interested in allowing experimentation, maybe there's a way we can get a nudge coming from across the pond into the US to get us to move forward a little more quickly. And so if we had a program where people could take the experiment that they're running in the UK and run that same experiment here in the US, you'd have some sort of information sharing agreement so that the regulators in both jurisdictions could get access to the results of those experiments. And we would have an open-ended enough program. Again, this is all me proposing and thinking about it. It's not official, but you could have an open enough program that allowed the project to operate on the terms that they had agreed with the UK regulator. And again, it doesn't have to be just the UK. You could pick any other regulator. Take those conditions, apply them here. And I think we'd get great value from that, seeing whether these projects work, seeing whether the conditions are appropriate, seeing whether they work differently and under different market conditions that apply in different jurisdictions. So I think it could be a real learning experience for us as regulators, but also it would provide the people innovating with the ability to try things without having to, if they try things on a small scale, you don't have to um, build a huge thing and then find out it doesn't work. You can try it. If it doesn't work, you can make adjustments. It's intended to provide that kind of flexibility.
Yeah. So as we think about, I guess this is a good time to think about maybe what a regulatory framework would look like in the US more in the medium term. You know, industry has proposed things that they might like to see in terms of tailoring rules or regulations. I'm sure there's challenges in registration because unlike a company that maybe files an S1 with the SEC and describes their business, you know exactly who the leaders are at that organization, the ownership structure, and so there's challenges that are introduced. Without getting into any sort of the specifics, what do you think as the SEC might think about more in the medium term about a regulatory policy in this space or putting out a concept release? What are some of the, I guess, core principles that you would like to see in that type of framework, and how would that clarity or those safeguards sort of benefit both entrepreneurs in the space and then also investors or consumers?
Yeah, well, I think to take the last question, having regulatory clarity will enable everyone to get a better sense of who's trying to play by the rules and who isn't. Now it's really hard because even people who want to come in and register can't. So you want to provide some sort of option for that to happen, and then you can figure out where who you might be more comfortable dealing with. But I think you could take different approaches to solving this problem. Whatever you do, you need to make sure that you're not baking in the way the industry looks now and making that the rule set so rigid that people can't do different things. I think that, and I give my other disclaimer, which is that I'm a regulator, I'm not a technologist, and so I don't know where this will end up going, but I think one of the powerful things about the technology is the ability to coordinate human activity across people who don't know one another. And that is an application that can be valuable in the financial services world, certainly, but also can be valuable in lots of other areas. You can imagine, social media platforms, news platforms, decentralized physical infrastructure. There are a lot of really interesting potential applications that you may not want to layer on a financial regulatory framework. So I think carving out areas that just are not in our space is important. We've spent a lot of time thinking about an issue, a particular legal issue, which is when is something a security and when isn't it? And even though we've got a lot of lawyers here at the agency, we've been a little bit legally imprecise in how we do that. So I think one of the first things you need to do is to start to lay out some markers. The token itself may be a security if it, gives you a share of ownership in something, or if it is like, it could be an equity or a debt security. So obviously those are going to be pulled into our regime. And then it's just a matter of figuring out, okay, if you take a share of stock and you tokenize it, what do we need to change in our rules to make sure that that tokenized stock can do the same thing that a non-tokenized stock would do? We had the same kind of question when we went from paper stock certificates to, you know, electronifying those, right? So these are things that we can deal with, we've dealt with in the past. Similar questions around do you need a transfer agent anymore if you're dealing with a blockchain? So you can tackle some of those kinds of questions. And then I think you have to start thinking about this investment contract question, which is, if you take a token and you make promises to people that you're going to build a blockchain, how do you want that to be regulated? Do you want there to be some sort of requirement that people who do that provide information about themselves? Like you were saying the S1 provides information about the people behind the project. You might want that same kind of information. But whatever you do, you can't expect these small projects to look like, a company that's going public, because they're just not. So can you tailor a regime that will allow some of the disclosures that you want around who's behind it, what are their plans, how many tokens are they keeping for themselves? Give us progress updates on how you're building out the blockchain. So thinking about those kinds of issues, and if so, if you want to have a disclosure regime, who should be responsible for it? Do you want to make the project responsible for it, or do you want to make the centralized intermediary where people are trading these tokens responsible? How do you want to deal with the question of when something, because the goal for a lot of these is to become decentralized. So how do you think about that in the framework? So there are a lot of questions like that. I guess I'm giving you a long answer, but I think we have a lot of things to tackle. And then questions around custody for investment advisors and broker dealers. What does that look like? What are the rules around that? And then you're at the PCAOB, so, thinking about questions around auditing, doing proof of reserves and things like that. Do you want to have some sort of regulatory framework for that kind of thing?
I imagine there's a lot of questions for each of the sort of regulators in that space. I guess I want to go back to your discussion of maybe a concept release around adding some new sort of safeguards here. You've got mostly academics in the audience here doing a lot of research on things that I imagine could inform, when a token becomes sufficiently decentralized that it doesn't look like a security. What are the boundaries, I guess, between CeFi and DeFi, as you described, some of the exchanges and custody issues? What's a good way for this audience? Well, two questions, so it's a two-part question. Number one, what are some topics that you might want to see research to sort of get ahead of this effort? Based on your background in economics and some statements I've seen you made, I assume you're a fan of evidence-based policy. And so I'm sure the academics in the audience could provide some of that evidence. So what's a good way for them to get involved sort of before a concept release is put out, based on either the knowledge we have or new knowledge that is gained? And then how can they participate in that rulemaking process? Since many will be unfamiliar, I think just describing that would be helpful.
Yeah, and so I am a fan of evidence-based policy. I spent time working at the Mercatus Center with economists, and part of the reason I wanted to do that is because I wanted to understand how economists think about regulation, and that has been very informative to me. And one part of that is just this very basic principle, which is before you start embarking on regulation, you really ought to be thinking about what problem you're trying to solve. And then thinking about, is that a problem that's actually going to go away on its own? Because if it is, you probably don't want to undertake a regulatory solution, because the regulatory solutions are much less flexible. They can have unintended consequences. But if you decide that there's a market failure, or there's some reason for you to undertake a regulatory solution, then you want to think about what the menu of regulatory solutions is. You want to sit them side by side, and you want to have an assessment of the costs and benefits of each of those, thinking about potential distortions that you might introduce into the markets, and the consequences of those distortions. And so I think that's an area where certainly academics can be very helpful in both thinking through the problem side and thinking through the solution side. Um, we we put out, if we put out a concept release or an advance notice of proposed rulemaking, we sometimes call it, that is an opportunity for people to comment. You can write a comment letter that can be as simple as, sending in a paper that you've written, or I mean, that's not simple to write a paper, but you can just attach that to an email and put it in the comment file if you think it's relevant. You can write a letter specifically in response to questions that we often include. And you can do the same thing on proposals. Look at what the proposal is, think about whether there might be some unintended consequences. I do think there's some base research that can be done. And so you mentioned, Josh, the concept that has been talked a lot about of where's the line between centralized and decentralized. And I do think that's an area where it would be interesting to see what academics say about that. Does that concept make sense for us to use that as a marker for where the regulatory framework applies and where it doesn't? If it does, then we probably need to know what decentralized actually means. And then I think there are interesting questions around how will a decentralized financial system interact with a centralized financial system? Will it add to the resilience, which I sort of think, that seems like it makes sense to me, that if you decentralize, you take out centralized intermediaries, you actually build the resilience of the system. But, academic work on that point would be interesting. Academic work on thinking about what are some of the costs and benefits of moving to much faster, almost instantaneous settlement, because our system has been set up so that you have a lag, and so we'll have a different set of problems because you take away much of that lag. So that's a set of questions people can think about. And then I think, the market effects of what does it mean when you set up an exchange traded product that has Bitcoin as its underlier? What effects does that have on the Bitcoin markets, or, other crypto assets? Same idea. And then I think of another area that's interesting, and Chris Brummer has done some work on this. He's a lawyer, but has sort of thought about how can we use the technology itself to improve our disclosure regime, because the ability to bake in information alongside the value. So if I mean, I think there's real potential in the bond markets, for example. You can embed the documentation right into the token. So how should we be thinking about that, taking advantage of the value of that technology in structuring our disclosure requirements? So I think there are a lot of really interesting ideas. And then thinking maybe too about which markets does tokenization make the most sense in. I do think there's great potential in the bond markets. I think there's potential. We've already seen some money market funds being tokenized, and some other private funds are thinking about tokenizing. It's a way of potentially taking real world assets and fractionalizing ownership. So, again, thinking about where does this make sense? Where are the problems going to arise when you have this separation between the real world? It's one thing to say you're selling something on chain, but how do you make sure that that link stays permanent so that the real world asset actually goes along with the token? So I think there are a lot of really fun issues for people to think about.
And it sounds like the list may be pretty long, and I'm sure the SEC will have a lot to digest as a lot of this information comes in. In terms of,
I mean, you've done work that is relevant to what the SEC does, and it really can make a big difference. And so I do recommend that as academics who are interested in these areas, look at what the agency that you're, that deals with the kind of stuff you're working on, look at what they're putting out, and do try to flag your research when it's relevant, because I look at SSRN sometimes when I'm looking at specific types that, I'm wondering, has someone written about X, Y, or Z? But it's much more helpful if someone says, "Hey, Hester, I'm working on a paper," or I've got a draft of a paper here. You might find it interesting. And then always have a good executive summary, because I can tell you, as lawyers, which many of us are, we're probably not going to be deep in the weeds on determining whether you've done all the math right.
Yeah. So if I hear it correctly, to operationalize that, probably the best path would be to put a cover letter addressing to the
Yeah.
commissioners and to briefly summarize your paper and maybe what rules it might be relevant to. And can that just be sent to the secretary at the SEC? Is that
Yeah, I
the
mean, so
best path?
typically there'll be if you want to put it in connection with a particular rulemaking, there's a number that rulemaking has. You just put that in the letter and it'll get then put in the comment file, which other people can see. Because the goal is then people can interact, so someone else can write in and say that they don't like your paper or they agree with your paper. But that's what makes it a dynamic debate, right? And you can respond to what other people put in and say, no, we think that person's comment was wrong. So you not only can respond to the commissions, and we do an economic analysis in connection with our rulemakings, so that's also something that you can respond to that. But you can also respond to what other commenters say.
Gotcha. So putting it, if they were able to link it to the right rules that have been proposed and putting it in the comment file, will allow the economists to know we should be thinking carefully about this and can potentially respond as the rules potentially become adopted. Is that right?
Exactly. And your comments will get read. And we have an obligation to look at all those comment letters. So you definitely can be part of the conversation. And there are also sometimes opportunities we sometimes have conferences. The Division of Economic and Risk Analysis does a yearly conference where people come and present their work. So I think that's helpful too. The other point I would mention is that I think it's really nice when people go on podcasts and present their academic papers, because it can allow for, especially when you're dealing with an audience that may not be steeped in economics or finance, it can be a way for you to kind of spoon feed the research, your findings, to people. And so I find that really helpful. And whenever I come across a podcast that does that, I really enjoy being able to listen, even if it's something that maybe isn't directly on point of something we're working on. It can kind of get me thinking, oh, this is maybe can help me approach a different problem that I see.
I like that medium too for being able to digest sometimes very complex research and sort of asking the so what question. That's a nice thing that podcasts, I think, do a nice job of. So we've got some questions coming in, but I wanted to ask you something before we get to some
And
of
then, can I just say something in response to that? Because the so what question is a really important question. And I think especially for academics, you've got to be thinking about that so what question, because a lot of the work that you all are doing is really relevant. But if you don't make the so what link, it might get missed. And so it really is, I really do encourage you to engage with what the regulatory world is thinking about.
Yeah, I think that's an important point, and just to make it very crystal clear so that there's no confusion, uh, because sometimes economics and results can be interpreted differently. And so making that very clear, I think, helps resolve any uncertainty around the so what question, I think would be
Yeah.
your thought process. So yeah, I wanted to ask, I guess, a little bit on the legislation side. I know there's been several bills introduced. Some of them are bipartisan. I know the SEC commissioners spoke to the House Financial Services Committee, and as part of that, there's almost always some bills introduced. And I know I don't want to really focus on any of the particulars of those bills, but I am curious to get your thoughts. Sort of, are there any particular aspects of crypto regulation, whether it's maybe some of the interagency work or different things we've spoken about, where you think legislative direction could be helpful?
Well, I always welcome legislative direction because it can, help us focus where Congress wants us to focus. So that's a good thing in general, and especially when you're dealing with what I think is it it is a new asset class, it's a new technology, and it's going to interact with our financial system in some unusual ways. It's going to make peer-to-peer transactions much easier, and so it is helpful for Congress to come in and tell us how they want us to be thinking about those things. So my natural inclination would be, for example, to say, hey, if two people want to engage in a peer-to-peer transaction without the benefit of an intermediary, that's they've sort of carved that off and said maybe that's an area where regulation doesn't have to come in because you don't have some of the problems that arise when you introduce intermediaries into the situation. If Congress feels differently than that, I think it would be helpful for some clarity there. But then I think there's some obvious areas where you see the CFTC and the SEC coming in and maybe coming into the same problem, but coming in from two different sides. So it would be helpful, I think, to have some allocation of jurisdiction if we want to have some kind of a framework where there's disclosure around assets that are not actually securities. Does Congress want us to do that, or do they want some other regulator to do it? And then I think, yeah, and same, trading platforms that are trading things that are not securities. We're pretty good at regulating both disclosures and trading platforms, so we can do it. But I think if we had a clear directive that, yeah, even though you're the SEC, we also want you to be involved in these things where the assets are not securities, or no, we don't. We want that to be at the CFTC, or we want you to share jurisdiction. And I think those are some of the things that you've seen in the legislation that has been out there so far, is they're really grappling with those kinds of topics. I think stable coins is another area where people have talked a lot about legislation. There have been drafts out there, and that could be very helpful because stable coins are one of the, really they've exploded as a use case. There's a lot of use outside the United States, but I think with a regulatory framework, you'd see more use in the US. I don't know that that's an area where Congress would give the SEC regulatory authority, but I think it would be helpful to have some kind of regulatory framework there as well.
Yeah, and one of the questions that came through was sort of get your thoughts on, and I think you touched on it some, and sort of ideal division of roles between the SEC and CFTC. So, do you have any thoughts on that, or maybe sort of how it's worked so
Well,
far?
I think we're sister agencies and we regulate markets that are very intertwined, and so there are a lot of times in my history with the SEC where I've seen the CFTC and the SEC come to disagreements about things, and how have we resolved those? And sometimes they've been resolved in ways that are, I think, good, and other ways they haven't been resolved well. And so having Congress say, okay, SEC, CFTC, here are your responsibilities, or we want you to develop a framework together, which is never easy. It's not easy for two agencies to do that. We have done that in certain instances, but if that's what Congress wants us to do, that makes sense. I mean, I guess what my main concern is making sure that whatever Congress decides to do, we don't set up a world in which everything that's non-financial has to run through a financial regulator, whether it's the SEC or the CFTC. And I heard an example this morning, which I think was a nice reminder to me. When, gaming is it's not something I've ever really been interested in, but it's something that a lot of people are. And one of the things now is you can buy in-game assets, and you can tokenize those in-game assets. And if you tokenize them, do you really want the SEC or the CFTC to be regulating those? So help us think through where neither of our agencies should be involved as well.
Yeah. I think that's describes the challenges that lie ahead, I think, is in answering how those set up.
But I mean, that's one of the frustrations too. We've lost a lot of time in sort of having this, all of this talk about when is something a security or not, but it's not been productive. We've not actually gotten clear rules, and so that's a frustration that we've wasted time. Now, the benefit of that is that we've been able to see what other jurisdictions have done, so that's an area we can draw some wisdom from, what's worked, what hasn't worked. But it also means that maybe we won't bake in the technology. We'll be able to develop technology neutral rules because we didn't try to start too early. So I'm discouraged about how long it's taken, but maybe we can turn that into a silver lining.
I like that silver lining. No, it's we could only plot the path forward from here, right? So that's what we'll do. So Jillian Grennan has a question. She's at Emory. One of them is, do you have any thoughts on licensing regimes? And one of the ones that she sort of references is New York has something like a bit license. Is that something that's sort of a role of a regulator? Is that better done at the state level? Is that something that you've given any thought to?
Yeah, I mean, New York came out there early with their bit license, and it got, some people thought it was good, some people didn't like it. I do think it's helpful. I'm glad you brought that up, actually, because there's another layer to the US regulatory system, which is that we do have this bifurcation between the state and the federal. And that can be very frustrating because if you've got to if you've got to get a bit license to operate in every state that you operate in, that can be a very time consuming, difficult process, depending on what it looks like. So that can dissuade some projects and companies from participating in certain states because it's just too much for them to do that for every state. On the other hand, it does allow us some chance to see how different approaches work. New York is one example. Wyoming has experimented a lot. Other states have tried to do different things as well. And so we have those state experiences. We can take those and think about how well they work. I think you have to sort of look at how it works for each regulatory entity, whether it's an exchange or whether it's a broker, and figure out where it makes sense to have that entity registered and regulated. And so I think it just depends, I guess, is my answer.
Got you. So yeah, is it correct that as the SEC, one of the things that sometimes rules can do is sort of preempt this blue sky notion of, instead of having 50 state regulators plus a federal one to deal with, sometimes those rules sort of overlay and replace the state rules? Or is there still going to be sort of this federalist system of every state I operate in, I have to get a license, plus I have to deal with a federal regulator? Because the problem you described with having too many regulators can become exponential in that point.
Right. Yeah. So I think, yeah, the fact that the SEC can displace state regulation, I think does sometimes. I like the laboratory of democracy idea of states being laboratories, but at the same time, at some point, I think it does make sense for a federal scheme to come in and say, hey, we want our national economy to work seamlessly, so we don't want to have these barriers at every state. And so we still work very well with the state regulators just generally on securities issues. They play a really important role. They're much closer to some of the activity. They can be very helpful in identifying problems. But I think there's definitely a place to say, okay, here the SEC is going to be the regulator. We're going to have one consistent scheme. I think you're seeing this play out now in a lot of disclosure areas. We've seen it play out in the question of whether there was a big debate a number of years ago around whether broker-dealers should be subject to a fiduciary duty. And we adopted a rule, and then some states came in and they adopted their own rules. And so again, that can add to fragmentation and make it much harder for competition to cross state lines. So definitely interesting issues to think about.
Issues and challenges, but hopefully, again, silver lining is that we may have some nice solutions. Another question came in that was sort of a perspective on know your customer, or this KYC. Would that potentially play into some frameworks the SEC can think about, and these sort of market-based solutions that have arisen. Is that helpful? And I guess that would be more on investor protection side, but what are your thoughts, I guess, on know your
Yeah, I
customer?
mean, investor protection, but also thinking about, the KYC, know your customer, anti-money laundering rules are really part of using the financial system to try to stop bad activity. And that's certainly understandable. We don't want terrorists and bad actors using the financial system um, to launder their money or to funnel money to terrorist activities. Um, and we do want to be able to use our financial system to identify criminal actors. I do think this is an area where we have to be very careful because, especially as technology improves, it's so easy for the government to surveil more. And often that surveillance is conducted through third parties. So we use banks to turn over information to us about their customers. That's been going on for a long time. But now the surveillance is better. And so we can get more of that information, process it better, and we can really watch what everyone is doing. And that may make us safer as a country, though there have been a lot of questions about how effective all of that information collection has been. But it also does potentially compromise our core American values. And I think this is a good time for us to sort of revisit that topic, think about how to get that balance right. Government needs to get information about bad actors, but we also need to protect people's right to privacy, and privacy in your financial life is really important. Um, and so whatever we do in this space, I hope we're thinking about that. And I hope we're thinking about the fact that when two people engage, you and your neighbor decide you're gonna buy your neighbor's dining room table, and you pay for that dining room table. No one has to report that to a that the exchange of money for that table to a there might be tax implications. I don't know anything about tax regulation, but that transaction, you don't have to do a KYC on your neighbor to do that transaction. And I don't think if we shift those transactions into the digital world, you would really want that either. So let's make sure that we're doing this in a sensible way. Let's make sure that we're really protecting core American values.
Again, we get back to balancing protection needs on one end without sort of overstepping boundaries. It seems to always be a challenge. There's a couple questions that came in about stable coins. One of them is asking, um, you know, based on evidence-based approaches to regulation, what kind of evidence do you look for? And this maybe doesn't have to be stablecoin specific, but when trying to assess the current impact of using stable coins for payments, the transmission aspect. And so maybe you can talk a little bit about would that be an SEC type role? Is that more of a treasury? Is that up to Congress to decide? But what kind of evidence would you look for in that
Yeah, I
space?
mean, I think a lot of that probably would fall outside the SEC, because if you're thinking about using stable coins as a payment mechanism, it's probably more a banking regulator type issue. It might be something that the Financial Stability Oversight Council, or there is an office at Treasury called the Office of Financial Research. That might be an area for them to look at. I mean, I actually do think that stable coins, I'm surprised there hasn't been more federal government interest in thinking about how stable coins will affect the U.S. U.S. monetary policy, U.S. the ability of the U.S. to sell treasuries, right? Because a lot of these stable coins are dollar backed, they're dollar based, and they're backed by treasuries. And so when we think about the dollar as the reserve currency, what effect will these stable coins have on bolstering that? Um, and so I expect there'll be research around those kinds of issues, but those really do fall outside our space. I mean, from my perspective, I'm interested in knowing how tokenized money market funds will be used. People have talked about using them as collateral for transactions. It could be a very efficient form of collateral. So um, That's the kind of thing I would love to see research on, is how can people use it? How are people thinking about using those products?
Yeah, there's all kinds of, I think, interesting questions there, and inclusivity and allowing people to transact. I got time for one last question, I think. And as we move forward, there's probably an expectation that M&A activity may pick up depending on changes at agencies outside of the SEC. But if there's a consolidation phase in the industry, are there any sort of hiccups that we might expect? And like, what can the SEC, I get this question all the time from reporters, what can the SEC do around mergers, or what do they look for there, and how do they try to prevent those distortions from spilling over to investors?
I think that the best thing the SEC can do to keep a competitive playing field is to have barriers to entry as low as possible. And so that means that when you're thinking about a regulatory structure, you should go back to those same core things. Figure out what the problem is and figure out what the most streamlined, if you have to have a regulatory solution, what is the most streamlined regulatory solution? Having super complicated rules, which many of ours are, end up deterring smaller, more innovative players from coming in. I've seen this in the crypto world, where you've seen people who are coming from outside the traditional financial world. They're engineers. They're thinking about solutions to problems in the financial world, and it's very hard for them to break in because you've got to have so many layers of lawyers. And so the best thing we can do is just keep that competitive landscape, those regulatory barriers to entry low. And I think that dynamism is what builds an industry that then serves Americans best, because if people get too comfortable, they stop thinking and caring about what their customers want. And so keeping that dynamism, keeping new entrants coming in, new products and services coming in, is what makes our markets healthy, I think.
Definitely. We like to think of that in academia as the market for control, and market forces can have a disciplining effect for sure.
Exactly. Yeah.
Yeah. So yeah, to be respectful of your time, I want to conclude and thank you for your time, and thank you for being so candid and forthcoming in the discussion, and also want to thank the audience for their participation. We really appreciate this, and want to also wish you the best over the coming months as there's a transition.
Well, thank you. Thank you, Josh, and thanks to the audience. It's been a really fun conversation, so I've appreciated it.
Well, that we will conclude. Thanks again. Have a great day.
You too.